Before we proceed to continue the lecture on the procedure for evidence, it's a continuation of the last. Anybody has any question, please ask me. Then I think last time we could not take up everybody's questions. I think we have so far proceeded to examine your various types of evidence, primary evidence, secondary evidence, isn't it? Examination chief, list of documents, how the court is going to mark your documents, what are the provisions which are involved. I'm sure you must have gone to the previous lecture. If anybody has any doubts, bataiye, then next I will proceed, because this today will conclude the trial on civil cases. Then next time we'll proceed on the trial of the criminal cases. Anybody has any question on the last topic? I won't be much repeating what was done earlier, isn't it? I have mentioned to you, broadly speaking, those who have not attended and those who have not seen the video. The plain written statement, your counterclaim are not strictly evidence within the Evidence Act. They are required to be corroborated by the person making the document by stepping into the box, isn't it? The provisions relating to the Evidence Act speaks of examination chief under section 137, then cross-examination, then the third one is a re-examination and re-cross-examination. There are 4 steps are involved. Please note that here. Examination chief of a person who filed the affidavit or who goes in the box and gives evidence. That is his examination chief. If you are the plaintiff, you are leading your evidence, it is your examination chief. If I am the defendant, I step into the box where the issues are framed against me. I had to the burden to be discharged under Order 18. The option to the party is given. Either the plaintiff may begin the suit first, or the defendant may begin the suit first. Now, normally the plaintiff who filed the suit is required to begin the matter first, lead his evidence. But suppose the defendant has taken the contention that the suit itself is not maintainable, there is for want of jurisdiction, and the suit is barred by limitation, then we discuss here the court may frame preliminary issue under Order 14 Rule 2 CPC. May take up the plea that here, before going into the merits of the case and wasting so much time in the trial, will decide the preliminary issue under Order 14 Rule 2. Now, formally, Section 9A CPC has now been deleted. We had a provision in the old CPC that Section 9A, even at the interlocutory stage, when a plaintiff files a suit, applies for injunction, the defendant could take the plea that the court has no jurisdiction, injunction should not be granted, and it should not be disposed of. Though ad interim orders can be passed by the court under 9A, but it would not be confirmed. So in a situation that was, then it was an appealable order, then a second appeal was to lie, then a matter goes to Supreme Court. So much of time was being wasted in the courts. So the legislature of Maharashtra, at the direction of the Supreme Court, in Wadia's case, they deleted this Section 9A from the statute book, which is applicable to the state of Maharashtra. But that doesn't prevent the court under Order 14 Rule 2A CPC from framing a preliminary issue to dispose of the matter. So, for example, the defendant took up the plea that this honorable court has no jurisdiction, and the issue of jurisdiction goes to the root of the matter. Or that so the court will frame this issue, whether the suit filed by the plaintiff in the court, in the High Court of Judicature at Bombay, or a district court, city civil court, is maintainable. It may be a suit for declaration. The plaintiff, he has filed that maybe, say, for example, in the city of Bombay, all of you know that here, there are lots of agreement of leave and license. Agreement of license for 11 months, 3 years, 5 years. So after the expiration of the agreement of leave and license, many lawyers are branding them. Defendant became a trespasser. A trespasser suit under Section 9 lies before the city civil court in Bombay or the High Court original site Bombay, depending upon the valuation. If the valuation is up to 10 crore, it will go to city civil court Bombay. And if the valuation is about 10 crore, about it comes to the High Court Bombay under clause 12 of the latest patent. So the common section for trying the suit is section 9 of the Code of Civil Procedure, whether the court has jurisdiction. So in a situation like this, the defendant has taken up the plea that, my lord, the present suit which has been filed by the plaintiff for a declaration that the suit is that the suit should be decreed, that the defendant is a trespasser, is not maintainable in the civil court, namely either in the City Civil Court Bombay or in the Bombay High Court original site Bombay, and this is exclusively triable by a court of small causes court under section 41 of the Presidency Small Cause Court Act, or under section 33 of the Presidency of the Bombay Rent Act, Maharashtra Rent Control Act. So that is a situation which arose before the Bombay High Court in one of the leading case, Nagin's case, AIR 1980 Bombay, page number 123, where Justice Marden and Justice Deshpande were required to deal with a situation like this. Whether when a agreement of leave and license between the plaintiff and defendant terminated, does the defendant become a trespasser? Because trespasser suits are not maintainable in the Court of Small Causes Court under section 19, because all title suits are required to be filed in a civil court. We should know that here, because this is the basic thing. When you become a young lawyer, you'll have to come to know that in which court has jurisdiction to entertain the suit. Well, you have to know the City Civil Court rules, Bombay High Court original site rules, and also the Small Causes Court Act and the rules. Section 19 of the Small Causes Court Act prohibits that here suit for titles are not maintainable in the Court of Small Causes Court. Suit for specific performance is not maintainable in the Court of Small Causes Court. This, please, section 19 specially.
Sir, I'm sorry to interrupt. Sir, what would be the remedy in such a case? Because by personal experience, I'm speaking now. The leave and license agreement terminated a month ago, and this was my parents' property. Now, what happened is I couldn't intervene. I sent a written notice, but after discussions after home, we had to retrieve that because the authority was in the hands of the father because he is the title owner. Now, I needed the same house for my own premises. Now, the agreement ended on 1st of October, and the notice was given on July of 31. They still took at least 1 month, 15 days more to vacate, and this was all on terms of verbal agreement only, that on basis of negotiations. Now, me being a budding lawyer, I still couldn't find recourse on anything because I didn't know that this is a trespass law. It is coincidentally that you're telling me that it becomes a trespass after the leave and license agreement is terminated. So, what the remedy would be, and also my main question being that a person who does not have the title to the property, as in who is a beneficiary, or who may have an interest in the property, like he needs to use this property for his own usage, can he intervene? Can he do something without the title owner's
from what
consent?
you say, it appears to be an agreement of leave and license in respect of a residential premises, isn't it? Is
Yes,
it a residential premises?
absolutely, yes, a flat in a cooperative housing
Then your
society.
attention is drawn to section 24 of the Maharashtra Rent Control Act. Under section 24 of the Maharashtra Rent Control Act, there is a competent authority appointed by the government in the state for recovery of premises, residential premises, from the competent authority, which is in Mahada building at Bandra on the 3rd floor. Please note
Okay.
that.
I would have noted.
Yeah, it will not, because it's a summary trial. Summary trial means normally it is supposed to be disposed of within a period of 6 months.
6 months, right?
6 months time. So you have to file an application under section 24 of the Maharashtra Rent Control Act
Rent control.
before the competent authority, learned competent authority appointed under section 24 of the Maharashtra Rent Control Act.
Control Act.
Yeah,
So,
it's because your agreement must have been registered agreement.
yes, completely, yes.
Provisions of now section 55 of the Maharashtra Rent Control Act, agreement of leave and license require registration. Now, in one of the judgment, Bombay High Court say that, assuming for the sake of argument, the agreement is not registered, the complaint is still maintainable. So you file a application before the competent authority at Bandra for an order of eviction. If the
Even though the district is Thane, so then
district Thane, then you will have to go to Thane. In the Thane, you take it up because there are powers given to the authority by notification.
All
Sometime
right.
there may be an authority in Thane, there may be an authority of Bombay who is acting as an officer for even Thane matter. There's the notification issued by the government of Maharashtra and Bombay High Court under Section 24. So
24.
I think I am sure it is a Bombay only. It is a competent authority at Mahada, third floor. So his jurisdiction come into play here after the termination of the leave and license agreement, after the by efflux of time or by breach of the terms and condition, the lessor may give a notice for termination, or the agreement is elapsed by what do you call it, after the period by efflux of time. Then
What
in a
if the
section,
licensee is pleading medical ground? So in this case, the licensee
medical
was
ground is not a
actually
valid. No, is not a valid ground.
not valid.
Not a valid
That is
ground.
great.
So
That
you
is
can
great.
straight away file a complaint for an order of eviction against him, and if
Right.
he doesn't, and you are also entitled to double the amount of compensation. Please check the provision.
Okay.
Double the
Okay.
amount. If the amount is suppose 50,000 or 1 lakh rupees per month, he is liable to pay double the amount
Double
of
the amount.
suppose. Now, in
Oh.
respect of commercial premises, the jurisdiction will be Court of Small Causes Court under Section 41 of the Presidency Small Cause Court Act. Where?
Okay.
हाँ,
Okay. 41. Yeah.
41 में आएगा ये, because it doesn't come within the purview of the Maharashtra Rent Control Act.
Rent control.
Maharashtra Rent Control Act, the Bombay Rent Act, it is exercising dual jurisdiction. One jurisdiction between landlord and tenant under the Maharashtra Rent Control Act, under Section 33 of the Maharashtra Rent Control Act, and that is a contractual relationship created under the Rent Act. Then suppose there is also a relationship of landlord and tenant under the Transfer of Property Act.
Okay.
Like, for example, you have created a tenancy in respect of a bank or a public sector undertaking, or a school or a bank or a
School or college institution.
so they are not protected under the Rent Act. Like, for
Ah.
example, they are not protected under the Rent Act. Section 3 of the Maharashtra Rent Control Act excludes them. And it's
So
a
only
open plot. Yes, if it's a
only
open plot,
individuals are under Rent Act.
yeah, they don't have Rent Act protection. Even
Right.
a open plot of land which must have been given by your grandfather to a tenant, early 50s and 60s, he cannot say that I'm a lifelong tenant. So Rent Act protection is taken away under the Maharashtra Rent Control Act even to open plot of land, because the idea is the tenant of a open plot of land should yield the property, hand it over to the landlord to make it available for development. So, what is the remedy available to the landlord owner to evict a tenant of open plot of land, or a company having a share capital of more than 1 crore, or a banking organization who are, then you have to go under Section 41 of the Presidency Small Cause Court Act. Suit for a recovery of a premises between landlord and tenant who are not protected under the Rent Act, and also licensors and licensees. Licensors and licensing. So your suit will come here if you are given a premises which is a commercial premises, will be filed in the Court of Small Cause Court Bombay for 41. The only requirement is that here when you go to the Small Cause Court Bombay, in respect of suits filed against banking company, suit against the statutory notice under Section 106 of the Transfer of Property Act to be given. That is the only requirement. Whereas under the Maharashtra Rent Control Act, a landlord has to give a ground of eviction under Section 15, 16 of the Rent Act. Without the ground being established, you cannot recover the properties. I mean, the tenant has not paid the rent to you for more than 6 months period. Then you have to give a 90 days notice under Section 15, which notice under Section 106. Okay, after giving up the
under Section 15 under 106.
Section 15 of the Maharashtra Rent Control Act, read with Section 106 of the Transfer of Property Act. And for the other grounds, normally under Section 16(1) A, B, C, D, bona fide requirement, subletting, and notice termination is not mandatory. In view of the Supreme Court judgment in Danpal Chettiar versus Yashodama ML, that is 1979 Supreme Court, page number 1745. That you go through Danpal Chettiar versus Yashodama ML. This is the 11 bench the 11 bench judgment of the Supreme Court, which is still holding the field. Okay,
Oh, yeah.
that is
Okay. Okay.
the legislation. So 106 notice is important in cases of eviction in respect of those tenants who are not protected under the Rent Act, and licensees are concerned is a privilege under Section 52 of the Easement Act. Please note that.
Hmm.
There is no
Hmm.
requirement of giving notice unless the relationship between the parties, the agreement mandate that here, yes, you must give 1 month's notice, 2 months' notice for termination. Otherwise,
Hmm.
under the provisions of Section 60, the leave on license agreement doesn't mandate that notice to be given. It can be expressed or implied. 52 license is a privilege. It is
Hmm.
not a right, isn't it? So for eviction of a licensee, the provision under the Rent Act is a Section 41 of the Small Causes Court Act. And in respect of residential premises, the provision
24 of the.
24 of the Maharashtra Rent Control Act. So this
Okay.
now again the situation which I spoke to you of Nagin's case, AIR 1980 Bombay, the Justice Mardan and Deshpande's judgment, which page number 123 it is. It says that here when a suit is filed by the owner, lessor, or a landlord against his licensee after termination, branding him as a trespasser, he is liable to be evicted because the suit was filed under the provision under the Section 6 before the Bombay High Court original site, because the valuation at the time was exceeding the jurisdiction of the City Civil Court. So earlier the jurisdiction of the City Civil Court was only 50,000. 51,000 onwards is used to come to the High Court under Clause 12 of the latest patent and read with Section 9. So, in the Nagin's case, because in view of the bar under Section 19 of the Presidency Small Cause Court Act, that the suit against a trespasser is not maintainable and a suit for title are required to be filed in a civil court. In a regular civil court, in the city of Bombay, regular civil courts are a city civil court and Bombay High Court. Of course, small causes court is also a civil court, but it is considered as a special court. Huh?
So if
It's
the
a
licensee becomes a trespasser after the ending of the
नहीं,
period, then civil में नहीं आएगा. फिर भी
नहीं,
हमारे में
it
competent
doesn't.
authority. It
Because
doesn't
his
matter.
initial entry was with your consent. No?
हाँ.
He cannot become he even assuming he's a trespasser and he was been inducted by you, and the suit should be filed only in the court of small causes court under Section 41. Because the
So
entry was initially with your permission. He was a
permission.
permissive occupier. Okay?
Yeah. Yeah. So after he became a trespasser, but that doesn't matter. Yeah, I got it.
Trespasser means somebody you went abroad. I am your neighbor, I encroach your property, I taken without your consent. Then I am a trespasser.
But
Suit
in
Good evening,
Nagin
sir.
judgment, a person who exceeded the term is still termed as a trespasser.
Yeah, suit trespass, for example, is Section 6 of the Specific Relief Act, isn't it? Yeah. You went out of Bombay, I'm your neighbor, I broke open the lock and taken possession of yours. Your
So,
remedy,
so an-
yes,
anybody,
I'm a trespasser, so I do not have a right title interest. The Section 6 suits are concerned, they are tried in a summary manner. They don't see the title, only the previous possession. So
So
obviously,
sir,
you are in possession.
if I recall reading the text, even something as little as keeping a pen on other person's private property can be held as trespass.
Yes, it is a trespass. So, Section 6 postulates, contemplate two types of suit. One is suit within 6 months, summary suit, summary nature of a suit without title. On the basis of possession, you can file a suit. Second suit
Huh.
under Section 6, subclass 2, you want to check it up, title suit can also be filed within 12 years' time.
Okay.
That is
sir,
a
but
suit filed
sir,
with
once,
it will be.
good evening, sir. Sir, if you let the person in, so if they are a tenant or if they are licensee or anything like that, then you cannot file suit for trespassing.
No, you can file a suit at rest, but your jurisdiction will be the Court of Small Causes Court.
Okay, sir.
You cannot come to the High Court or City Civil Court branding them as trespasser. You even assuming there is a judgment of Justice Pence in that regard, if you see that here, assuming a person who came initially as your licensee or a tenant after the expiration of the period doesn't vacate, though you may brand him as a trespasser, but his initial entry was with your consent, so he is a permissive occupant. all permissive occupant suit should be filed in the court of small causes court, not in the High Court or City Civil Court under Section 9. Section 9 is a departure. So you should know the jurisdiction, landlord and tenant suit jurisdiction, Section 33 under the Maharashtra Rent Control Act. And licensors who are not protected under the Maharashtra Rent Control Act, and even tenant and landlord who do not have contractual relationship under the Rent Act, like for example BPT. BPT Bombay is the biggest
Bombay
landlord.
Port Trust.
Yeah, Bombay Port Trust. It gives premises to various persons, go down, everything. So they
Right.
come under the they are not protected. Those licensees under the Rent Act. So the suit will be filed under Section 41.
Got it, sir. Thank you.
And LIC LIC is also biggest landlord. So if
Landlord.
suit the government of India, there's a special act, eviction of premises. Special there's a estate officer appointed. So like this
Okay.
here. So this
So
interesting
why is LIC given special privilege, sir?
who
No, not LIC in per se. I think just
because public premises they should be immediately vacated. A summary disposal. The small causes court, city civil small causes court being a civil court, take a longer time. Trial will take extensive time. And before the estate officer says chat pangni pat biya. It is not a lengthy trial. It is like how the supposed to be. Even arbitrators are not supposed to be court. They are called
external body.
the evidence strictly cannot be laid before them. They are tribunals. Like consumer court is a tribunal, isn't it? So they are
Commercial tribunals.
they are supposed to be disposing of the matter expeditiously, but arbitrators also have vested interest. They delay the matter because the fees is paid every month, hourly basis, isn't it? So arbitration matters are not disposed of quickly. So here both the arbitrator as well as the lawyers appearing, they have vested interest in prolonging, and especially in big contentious issues involved, and matters are never disposed of. So the very object of arbitration, tribunal, consumer courts are with great respect are questionable, unfortunately, because we have too much of litigation. That apart. So the question which we were discussing now here, how when
Coming
a
back to
different
Nagaland. Sorry.
yeah. Yes. So your query is answered in
Answer.
respect of
Completely. And with a practical point of view.
Yes, Section 24 you have to invoke, file it before the Bandra. If you have any difficulty, approach me, I'll help you out. Okay? No problem. Because I had done several such matters and he got them evicted.
So you were saying the query we were discussing. Sorry to interrupt.
Yes, that was the query. Yes. Now the question I was saying that here, normally when I told you under the provisions of Section 18 of the Code of Civil Procedure, right to begin, the plaintiff has a preferential right to begin the case because he has filed the suit. But the owner's burden of proof under the provisions of the Indian Evidence Act, Section 101 C 114, there's a topic called burden of proof. All of you have studied that. So the burden keeps on changing and shifting. It is not mandatory that here the plaintiff only should start evidence under the Evidence Act given he files the suit. No, not mandatory. If the defendants had taken the plea that here this honorable court does not have jurisdiction to entertain and try the present suit, or the present suit is barred by the doctrine of res judicata under Section 11, the court may think that under Order 14 Rule 2, ab check karenge, there is a provision which says that the court can dispose of the matter on a preliminary issue. So the court can try the preliminary issue. Does the defendant prove that the suit is barred by limitation? Or does the defendant prove that the court has no jurisdiction? Or does the defendant prove that the suit is hit by the doctrine of res judicata? So the onus will be upon whom?
Plaintiff.
Defendant has raised his plea. Plaintiff has filed a suit for eviction against the defendant on the ground that he is a trespasser. But defendant then takes up the plea, I am not a trespasser, I am a deemed tenant. or irrevocable licensee. Irrevocable licensee under the Easement Act. So he cannot be evicted.
Or even better, sir, I am the owner, and these were installments that I paid to become owner of the property.
Yes. So the owners, the owner, if the owners of leading the evidence will shift from plaintiff to defendant. The court will say the defendant takes up the plea. This court has no jurisdiction. Court will be आप prove कीजिए, because you now open up your the Evidence Act. How the evidence shift is 100 and section 101. Yes, I will read you again for your section.
Sir, so the defendant will take the plea that either he is a deemed tenant, either he is an irrevocable licensee, or he
Irrevocable
is.
licensee, I become a owner by adverse possession. He may take up the plea. The suit is filed after 12 years.
Ah,
I have become owner by adverse possession under Article 65 of the Limitation Act.
sir, so
Isn't
what will
it?
be the remedy then in such a case?
So that means the court will give an opportunity not to lead evidence. You prove it, bolenge. Section
Oh,
1.
so then the burden of proof will lie on the defendant and not on the plaintiff.
That is what I am telling you. Section
Aha.
18, Section 18 CPC tell you who should begin. So normally the plaintiff begins. But now
Huh.
since the defendant has raised such issues, the court bolenge aap shuru kijiye abhi, because you are the person. So it's a preliminary issue I have framed. Because I
So
am not
whoever
saying. So when these issues are framed, so you have to bear in mind burden of proof. Section 101 से शुरू होता है. Then on 102, on whom the burden of proof lies. Burden of proof in a suit for proceeding lies on a person who fails no evidence and given either side. Then burden of proof on a particular fact, 103 ke andar. So I won't be reading all this, but you go through minutely, because earlier the Evidence Act was being regulated. Now it is, we have the provisions of Bharatiya Sakshya Adhinayam 2023. The relevant provisions are section 101, 102, 103, 105. So I won't be reading the sections, but you make in mind. So in such a situation scenario, when the defendant takes up the plea that the court has no jurisdiction, the court will ask him, you come in the box. Because I am only trying the issue relating to jurisdiction first. Because if the court has no jurisdiction, how the court can pass any order on merits? The court will come to the conclusion, for example, yes, the suit which has been filed in the civil court is not maintainable. The court, then what is the remedy? The court will say that the plaint be returned to the plaintiff for presentation in proper court. So, following the judgment of Nagin's case, the High Court or City Civil Court may come to the conclusion the suit which has been filed by the plaintiff on the ground that defendant the trespasser is not maintainable, because he was not a trespasser at the time when the relationship, or admittedly he was a permissive occupant. A permissive occupant suit will not lie as a trespasser. It will not lie in the City Civil Court or Small Causes Court. In the High Court, it will lie under Section 41 of the President of the Small Causes Court. So for that purpose, you have to know the judgment of Nagin's case. That is AIR 1980 Bombay, page number 123. वो पढ़ेंगे आप समझ में आ जाएगा. You come to know that. So that is how the evidence is led. The defendant will go into the box. If the defendant produces the relevant provision, the court will give opportunity to the defendant or plaintiff. You want to lead evidence on legal point, or you want to argue orally. Normally, the lawyers would say that in a issue with regard to jurisdiction, they would say we will lead oral arguments. Evidence need not be. But sometimes the parties may insist that it requires leading of evidence, where examination, cross-examination, re-examination hoega. So that is the. But in the if the defendant takes up the plea that the suit is barred by res judicata, yes, again the issue can be tried as a preliminary issue. So what is the onus upon the defendant? Defendant will go into the box. There was a previous litigation between the plaintiff and defendant's father in respect of the same property. That suit was That suit was finally heard and evidence was led. The court was pleased to dismiss the suit. I produce herewith the certified copy of the judgment of the previous suit. So the court will take on record. But of course, this has to be filed by virtue of your examination chief under the provisions of section 137, read with order 18 rule 4 CPC. Now, because earlier examination chief, you go in the box and read it. Now, with a view to avoid time, the legislature permits you to file an affidavit and your list of document, isn't it? In the list of document, the first document will be the certified copy of the previous suit. A certified copy is regarded as, though it is a technically speaking a secondary evidence, but the document of a court is a public document within the meaning of section 74 of the Evidence Act. So it will be admitted in evidence. But even if you have an ordinary copy, if the defendant is not objecting, under the provisions of section 58 of the Evidence Act, is admitted facts. Admitted fact need not be proved. Court can take a judicial notice, yes, the document is proper. So the court will take on record the certified copy of the judgment and decree which was passed in the earlier suit. Please note that there is a difference between a judgment and decree of a previous suit which was dismissed for default and a judgment and decree which was passed on merit after recording evidence. For the purpose of section 11 CPC, that is res judicata, only those suits which have been concluded after leading evidence, where parties were given opportunity to do lead examination chief, cross examination and re-examination. Opportunity, agar it had happened, then only section 11 will come into play. Otherwise, you say that the defendant, the plaintiff filed the suit, he did not remain present, the suit was dismissed. I produce here with the copy and the second suit is barred. No. Because the suit must have been disposed of on merits. Then only provisions of section 11 can come into play for the purpose of tendering in evidence. Okay. The defendant successfully proves before the court, yes, there was the previous litigation on the same point, same issues between the same parties or their representatives. Court will say there is no point, it's a futile litigation. I am not going into the merits of the case, whether it's a trespasser, whether tenant, whether irrevocable licensee, whatever status may be. But the fact that there is in existence a judgment and decree of a competent court in a prior suit between the same parties, the present suit on the same cause of action does not lie. Okay. So the defendant has successfully led evidence discharge his burden. The court will say the plaintiff may make an, of course, this is an appealable order under the provisions of section 96. You can file an appeal to the superior courts. वो अलग बात है. I'm conducting trial court में. So the plaintiff may make application, the court may try other issues. No, not necessary. So order 14 rule 2 may check करेंगे आप, the court can pass it. So the object is that the court should not be wasting its time. Okay, that is one thing. See, yeah, then normal course may the plaintiff will, once the plaintiff files his examination chief under the provisions of order 18 rule 4 CPC and read with section 137 of the Evidence Act. Then his list of documents are produced before the court of law. So I made it clear to you last time. Evidence in such matters, the nature of evidence which is led before the court is number one, primary evidence which is dealt under section 60. Then secondary evidence which is dealt under section 63 and 65. Primary evidence mean the original document. The document speak for itself. And secondary evidence mean the Xerox copies.
Yeah,
The
this is discussed, sir. Yes.
this we had discussed last time.
Yeah,
Then
yeah, yeah.
the direct evidence also, section 59, where the parties give it here. Then there is one more evidence called extrinsic evidence. That is, yeah, have you heard of the extrinsic evidence?
No,
No.
no, no.
Extrinsic evidence is covered under the provisions of, if you have your Evidence Act, there are खोल
Sir,
लीजिए
is it
मैं
like
बता रहा हूँ.
bloodshed and blood splatter? Blood
Section
splatter and
91
actual
से
mark?
लेकर, no, extrinsic evidence mean actually oral evidence to prove the contents of a written document. Normally, when suppose a lease is before the court of law, leave and license is before the court of law, the documents speak for itself. You are not permitted to lead oral evidence. You are not supposed to vary the terms of the agreement. But the defendant takes up the plea that here this document he was compelled to sign this document under duress.
So what is oral evidence? I'm sorry, a basic question.
Oral evidence matlab zabani. Section 59 of the Evidence Act. Direct evidence is the oral evidence, which is not supported by documents. Testimony. Well, they say chashmadid gawah. Chashmadid gawah. Oral evidence.
अच्छा कोई आके बॉक्स में कुछ बोल रहा है तो वो ओरल एविडेंस हो गया.
A person who has seen it, the person who has heard it, a person who is familiar with the transaction.
Got it.
Okay. Now the defendants will take up the plea. I am just telling you, for example, a flat which A wanted to transfer it to B for consideration. B will take up the plea that here this document is a forged document. It's a fabricated document. Consideration was not paid. The defendant brought revolver and put over my temple. He told me to sign it, otherwise I'll kill you. अब ये सब डॉक्यूमेंट में तो लिखा नहीं होगा. So you should be normally, your agreement is very clean. Okay, the plaintiff is the vendor will say that I sold it to the purchaser. Purchaser paid consideration to me.
In fact, unreasonable defenses are taken in practicality in real life, like actually.
So yes, it is taken. So sometime when these documents, when a consideration is not paid, when agreement is signed under duress, when free consent was not given, read section 15, 16, 17 of the Indian Contract Act. Without free consent, the contract is void. No consideration, no con.
So that we are aware. So if such a defense is taken, then what?
Such a defense can be taken. Evidence, normally Evidence Act does not permit you. Section 91 does not permit such evidence to be taken. But section 92 के अंदर there are proviso number 1, 2, 3.
So the burden of proof will be, if I take the defense that this was a forged document, then the burden of proof is on me.
Burden of proof will shift upon the defendant. Whoever has taken the plea that the agreement has been fabricated, forged, then you prove it before the court. Because the law relating to the pleadings with regard to the fraud and must be specifically pleaded. So the onus will be upon the person who has section 106 of the Evidence Act tells you a person who has a special knowledge must depose first. Do you have a special knowledge how you have been victimized, how a fraud has been played? So उसके लिए proviso number 1, 2, 3, 4, 5, 6 in section 92 देखेंगे, exclusion of evidence of oral agreement. You may say that the agreement which has been produced before the court is a sham, colorable, bogus document. I never signed it. Or you may take up the plea that here, this lease agreement, I was compelled to sign it for a consideration for a lease amount of rupees 100 rupees. When in fact the market rate is about 1000 rupees. The plaintiff, the lessor, wanted to evade taxes from the municipal corporation. Rateable value बढ़ जाएगा आपका प्रॉपर्टी का, तो इसीलिए because he was taking cash amount from me. These are sham colorable transaction. When no money is paid or less money is paid, a fraud come into play. Fraud is not on the record. For proving fraud, you are permitted to lead oral evidence, that is called extrinsic evidence, under section 92. And for varying the terms and condition, read section 99, which permits you, we say that who may give evidence of agreement varying terms of document. Persons who are not parties to document or their representative in interest may give evidence of any fact tending to show the contemporaneous agreement varying the terms of the agreement. So normally, plaintiff and defendant who have executed the agreement, vendor and purchaser, they have to give evidence. But यहाँ पे third party, a broker will come and say before the court, ऐसा कोई transaction हुआ ही नहीं, estate broker. So third person is permitted to lead evidence under section 99. You may examine witnesses. Such consideration was not taken. And bogus persons have been brought before the registration authority. I never went. I was not in Mumbai at the time registration took place. I was in Dubai. I was in America. You may produce evidence of alibi under section 11 of the Evidence Act. Isn't it? Alibi evidence, how it is approved. I was not in existence. I was not there. And secondly, let them prove the consideration. Under section 25 of the Contract Act, a contract is void if there is no consideration. A property worth crores of rupees, he has trespassed into and he is showing bogus agreement. So you may take up the plea that year, I may be allowed to lead evidence under section 96 to vary the terms of oral evidence to prove that such contract had not taken place. You may produce before the court your bank account. You may produce before the court. You may call upon the defendant. You are hereby called upon to produce document, your checkbooks, your demand draft, whatever document, books of account showing that consideration has been paid to me. He may fumble. I paid it to your father. Prove it. Because every document above more than 100 rupees requires compulsory registration. Immovable property, mandatory registration. Mandatory registration doesn't mean that you don't pay consideration. That is why now the registration authorities are very strict now. Isn't it? So these are fraudulent transactions do take place. Even in the share market, lot of bogus transactions go on. The brokers, sub-brokers, they commit lot of offenses. Offenses of criminal breach of trust, offenses of misappropriation. Even a person was not there, you pledged a document with him, किसी और को भेज देगा वो.
Sir, what is the proof for alibi? Alibi is valid tickets and valid.
100%. You may take up the plea that here I was not in Bombay at the time when the so-called execution took place. You produce your passport. You produce your visa document. I was in America. I was in London, out of India. How can a person who was not in Mumbai could have signed the document? By no stretch of imagination, I could have been present here when I was in Mumbai. I had not given anybody power of attorney. तो इसीलिए आजकल पावर ऑफ अटॉर्नी भी प्रॉपर्टी ट्रांजैक्शन में कैंसिल किया है, except for near relation, blood relation. Now you cannot give power of attorney to your broker or relation, you and your cousin, unless you are blood related.
So you can't even give it to your lawyer?
You can't give it to your lawyer also. Lawyer misappropriate too. Lawyer also human being.
Maybe first person is misappropriate.
Lawyers cheat more, many of them, with due respect. Lawyers are responsible for creating chaos in the profession. So lawyers are not paragon of virtues. Now you heard
It
recently
depends on the lawyer.
even a judge also got arrested. Sorry, FIR is supposed to be put on him. There's a demand for 25 lakh, 35 lakh rupees, and a court officer has been, Shereshadar has been arrested by the police on the ground that the money has been collected on behalf of a judge, particular judge. So we are all, there are a lot of black sheeps everywhere. Advocates are not a paragon of virtue, and the judges are also not clean completely. There are many of them. They are good people, bad people everywhere. Huh? Pardon? Yes. So this is how you lead your extrinsic evidence. Please remember the provisions here. Even third parties are permitted to lead it here. Okay. Then Evidence Act ke andar, during so of course I mentioned to you that while exhibition of the document, the discretion of the court is very wide. Now normally the parties are permitted to lead evidence and ask questions in respect of relevant questions, isn't it? You are not permitted to, whereas a judge has a right to ask questions to any person, relevant or irrelevant, under section 165 of the Evidence Act. Please note that section 165 calling an up. Now it is a 165. Now it is 168 in the new act, that is Bharatiya Sachi Adhiniyam. So very normally you are not permitted to you have to see when examination chief you are conducting, when you are taken up the plea that the defendant is a rank trespasser, does not have right at interest, and you cannot introduce other issues. I mean, you may take up the plea in evidence that there was a loan transaction between him and my father, he could not pay the lend, so and so. The other side may object it. ये तो प्लेंट में स्टोरी नहीं थी, ये एविडेंस में आ रही है. Examination chief is normally confined to the pleadings. The pleadings, that pleading means plain written statement. And issues framed by the court. You can only lead evidence. What are the issues before the court? You cannot be permitted to travel beyond the issue. But whereas in a cross-examination, a cross-examiner can exceed his brief. How it can be done, I'll just point out to you here. In cross-examination, the questions may come with regard to impeaching the credibility of a witness. Whether the witness is truthful or not truthful. You can go to the extent of asking his qualification.
That's all on the mind.
You are a competent person. Whether you have a degree or not. Or you can ask him, produce your degree papers. An expert may try to give evidence before the court. I am an expert, handwriting expert. उसके पास कोई qualification ही नहीं है.
Sir, can you ask for time during cross? Can the defendant who's been asked questions ask for time during the cross? Like if the cross examiner is asking me produce the degree, then can I say that I will give it after, like I need time to produce it?
Yeah, or time can be given. Produce it the next date. If he's not producing it, now issue him notice under the provisions of there is a provision under the notice provision, section 163 in the Evidence Act.
Matlab he may be able to stall a question. Like he can stall a question.
You call him, give him notice, because normally before the commencement of the trial, the parties are required to produce all the documents.
Right.
Except the documents which are meant for the cross-examination of the other side.
Yes, that will be out of the blue.
You can suppress it. Suppose in a, for example, in an adultery case, the husband or wife have filed an adultery case. So you are joined the paramour as the respondent. So तुम्हारे custody में letter आ चुके हैं. Your client, which he or she wrote to his boyfriend or girlfriend. Those letters you need not disclose. You can catch hold of him in the cross-examination. Did you write any letters? How your intimacy? Nahi karega. Look here. Are these your letters or not? Because you are familiar with the letter. Similarly, in cases like bona fide requirement cases, landlord will take up the plea. I do not have any house in Mumbai. Or tenant will say, I do not have seven except this house, nothing else. But you made inquiry, half a dozen premises. Certified copy le lijiye aap. Huh? So they are available in the public domain. Keep it ready with you. The defendant has a house in Kolaba, maybe in Andheri, maybe elsewhere. So you may ask him a question. Please tell the honorable court how many premises you have got. I don't have anything. Are you sure? You may ask him, what about so and so flat in Kolaba? I don't know. Produce certified copy आपने obtain किया. See, look here, is it photograph? वो पूछेगा, who told you all this? बोला nothing to do. Is it not or not? So this document you need not disclose to him. You can catch hold of him at this stage. Suppose he must have deposed in criminal proceeding something else. His evidence to the contrary, sometime parallel proceeding. So you can use that evidence in the civil court to prove that he is a liar. That provision to prove, you invoke the provisions of other evidences, section 33 of the Evidence Act. Under 33, whatever deposition pleadings in the previous proceeding can be asked in the question here. Similarly, there may be a breach of trust, breach of peace in the locality. You invoke section 145, 146 proceeding before a magistrate's court. So the magistrate is examining your title. In the meanwhile, you filed a suit in the City Civil Court or High Court, Bombay, under section 6 of the Specific Relief Act. So that parallel proceeding, breach of peace under 145, 146, where the magistrate appoint a court receiver. Magistrate को power है under section 146 CRPC to appoint a receiver until the civil court decides. Evidence was recorded, inquiry conducted by the magistrate, could document produce किया है plaintiff ने. So those documents which are produced by the plaintiff or defendant in the criminal proceeding, you can use against him and cross-examine him. Number one, for protection of those documents, the court may, the other lawyer may object here. How civil evidence given in criminal court is binding on civil court? Not binding. He may object it. But you should know as a good lawyer, section 33 of the Evidence Act. Section 33 permits you to invoke the provision. I will briefly give you the illustration how 33 come into play. Just see that here. Section 33. Relevancy of certain evidence for proving in subsequent proceeding the truth facts stated therein. So you have a right to obtain the certified copy from the magistrate's court and corroborate him or contradict him. Provision for contradictions are section 145. See, very important tool for cross-examination. Section 145, you can contradict a witness on the basis of his previous statement by pointing out that in the civil court you are saying one thing, in the criminal court or a family court you are saying different thing. Which statement is correct? Section 145 खोलिए आप Evidence Act. You will come to know how to use the document. So, because document which are used under the provisions of Order 7, Rule 14 tells you you are bound and liable to produce all documents. Similarly, Order 8 under Order 8 Rule 1A, defendant must produce all documents. But there is an exception. Document meant for cross-examination need not be produced. तो उसके लिए 145 देखिए, cross-examination as to previous statements in writing. Now this says that a witness may be cross-examined as to previous statement made by him in writing or reduced into writing relevant to the matter in question without such writing being shown to him or being proved, but it is intended to contradict him by the writing. His attention must before writing can be proved be called into content. So police में FIR में कुछ और statement किया है. 162 स्टेटमेंट और कुछ किया है, सिटी सिविल हाई कोर्ट के अंदर अंडर सूट में कुछ और स्टेटमेंट किया है. So you can catch hold of him by impeaching his credibility under section 146. देखिए यहाँ पर 140 question lawful in cross examination. Number 1, to test his veracity, discover the truth. Number 2, shake his credit by injuring his character. Similarly, the another important section which you can ask question shaking his credibility, section 154 of the Evidence Act, for if you are a cross examination. The court may in the discretion permit a person who calls a witness to put question to him which may put cross examination adversely. And section 156 question में corroboration के लिए. So you should know what are the sections under the Evidence Act. If you want to be a trial lawyer, Evidence Act should be by heart to you. If you are practicing both CPC and civil law, criminal law, the Code of Civil Procedure and CRPC, now BNSS, should by heart to you. You should know each and every provision. Without this, you will not be able to cross-examine. So impeaching the credibility of a witness or corroborating documents or proving that the witness is wrong is all given here in Evidence. So that is how the law mandates that here the plaintiff or defendant must disclose all the document but except the document meant for cross-examination, for which purpose you can invoke your powers as a cross-examiner under section 145, 146 of the Evidence Act. Okay. और कुछ पूछना है आज का? Evidence Act is much more lengthy and the topic cannot be covered in
which
one
section says that all the documents except for cross-examination?
Please open Order 7, Rule 14, follow CPC. I will read it. Order 7, Rule 14, खोलिए.
Sir, at relatives' place only I am carrying
Okay,
BNS.
I am reading it to you for your benefit. Order 7, Rule 14. Protection of document on which the plaintiff sues or relies upon. See, where a plaintiff sues upon a document or relies upon document in possession of power, support, he shall enter the document and shall produce it in the court when the plaintiff is presented and shall at the same time deliver the same document to the other side. Number 2, where such document is not in possession, power.
It's fine. We'll read it, sir.
Number 3, देखिए, document which ought to be produced by the court by the plaintiff when the plaintiff is presented enters so and so. Number 4, nothing in this rule shall supply to document produced for cross-examination. Sub rule 4. Okay. Then this is for plaintiff. For defendant के लिए order 8 rule 1A. Order 8 rule 1A check करो, वो भी काम आएगा. Duty of the defendant to produce document, same language is used. And then 3, Order 8 Rule 3 में, a document which ought to be produced by the court defendant under this rule shall not be produced so and so. The Rule 4, nothing in the document to produce shall apply for cross-examination. So this section should be linked to section 145 of the Evidence Act, read with section 146 for contradicting the witness. Even maybe FIR में कुछ और लिखा है and recording of statement under 162 CRPC में कुछ और लिखा है and statement evidence given to magistrate under 145, 146 relating to possession, वहाँ पे different story है. So you invoke your powers, the provisions of section 33 of the Evidence Act, and contradict him under section 145 of the Evidence Act. In the civil court before the High Court, City Civil Court, you made a statement, you are in possession. Is it correct? Then you draw your attention. Is it correct that both the parties have resorted to 145, 146 statement? Yes. You have filed a FIR? Yes. In the FIR statement, your statement is differing. And so and so. Now, which statement is correct? Please explain to the court. ये सही है, वो सही है. Both cannot be true. Then your next question, I put it to you that you are deliberately lying before the court. I put it to you that you are trespassed into the premises. I put it to you that you are a rank trespasser. I put it to you that you do not have any right title interest. I put it to you that you have committed gross offenses. So that is how you wind up your case in cross examination. You must put up your case. After pointing out, if you don't put up your case and also contradict him on his own statement, and you will not be able to succeed in the cross examination. Okay. कुछ सवाल तो पूछ लीजिए. I think my junior is pointing out to me. Time is up. Time हो गया? I don't mind extending for 5-10 minutes. You a question session ले लीजिए आप. Question answer ले लीजिए. You ask me question, I will deal with it.
So just 2 minutes. We'll just. Sir, one thing that comes to mind: a state officer is appointed for public properties.
Yes, under the Public Premises Act. He is the competent authority. He is the competent authority under the Public Premises Act. That is LIC ki property, government ki property, railway property, anybody trespassing,
Police
anybody.
property.
Yes, yes. यहाँ पे under section 24 competent authority under the Maharashtra Rent Control Act, which office is at the Mahada office, Bandra. Yes.
State officer, current state officer.
या स्टेट ऑफिसर की ऑफिस आपको सचिवालय में मिलेगी, LIC के अंदर. So that order passed by him is appealable to City Civil Court, Bombay.
Okay. Okay.
Order passed. Like a charity commissioner passing order under section 51 of the Bombay Public Trust Act, appeal lies to City Civil Court.
So, sir, और ये नागिन केस में क्या हुआ था सर? वो actually, so I know you said to read, but basically Nagin's case was saying that trespassing only, right?
Yes, that was a suit where the plaintiff had given a suit by premises on leave and license basis to defendant for a particular period, maybe 11 months or 3 years. तो agreement खत्म होने के बाद उसको बोला कि he is now a trespasser. Now under the provisions of section 19 of the Small Cause Court Act, suit against trespasser will not lie. So the owner filed a suit in the Bombay High Court. On the ground,
so will not lie in a which court? Like
Bombay High Court original site.
Acha, okay.
Because the valuation of the property above 50,000, then now it is about 10 crore, would lie in the High Court. Abibi. Please note that. Bombay High Court has original jurisdiction under the clause 12 of the latest patent.
Sir, do I have your permission to share a case on trespass that I'm myself sort of involved with? Yes. Or should I take it off?
Saying something, you were completing that Nagin thing.
Nagin's case, dekho, 1980 Bombay page number 123. That is one of the case where, because in the meanwhile, in the year 1979, the Bombay High Court rules, City Civil Court, Small Causes Court rule were amended. Samjhana aap? By virtue of the amendment, exclusive powers were given to Small Causes Court. Now, section 41 of the Presidency Small Cause Court Act starts with a non-obstanted clause, notwithstanding anything contained elsewhere in this act. It's a overriding powers. Exclusive jurisdiction were granted to Small Cause Court in respect of all matters between landlord and tenant which were not covered under the Rent Act. So, notwithstanding anything is a non-obstanted clause which you must have learned under the interpretation of statutes. I don't have to explain to that. Okay? और कुछ पूछना है पूछ लीजिए. Why? Can you hear me?
Yeah, sir. I have one small query.
Yes.
I got into an agreement with a trust to rent out their shop, but the way the market operates is they don't do an agreement. So I did a MOU. Unfortunately, or again, as the market practices, that was also unregistered. It just so happened that after a few days, the previous occupant of that shop came to me and alleged theft of the goods that he alleges to have been stored there.
Yes.
That has resulted into a criminal complaint against the trustee and also me.
Criminal breach of trust 406, 409 लगा दिया होगा.
Yes, sir. So, I have generally got dragged into this nonsense without this thing. So, I've been wondering since this guy,
You
the
go
old.
to the High Court for quashing under 482.
Yes, sir. That's what currently we file discharge, and then if it does not work, then we'll go for quashing.
Like for quashing, because it's purely a civil matter is sought to be painted with a criminal color for no mistake on your part.
Right, sir.
Yeah,
Right,
because
sir.
you at the most you can be termed as a permissive occupant, a licensee within the meaning of Section 52 of the Easement Act.
No,
Okay.
perfect, sir. So I was wondering if I can file a case of trespass against the old the old occupant who forcibly entered into my premises and said that you
But did
you
you surrender the premises to the trustees before you came? Did you surrender?
Yes, he had surrendered, but there was some illegal jol
A
between them, and
person who has surrendered is defined under the provisions of Section 111 and 14 of the Transfer of Property Act. So possession should have been given back to the trustees, and trustees creating a new contract with you. You can only file a suit for trespass against them if there is a surrender, valid surrender.
so there was a valid surrender, and there
If
was
there's a valid surrender, you will succeed. You can file a suit for trespass against them.
right, sir. But there was an sort of informal
File a
kind of
suit under
arrangement for
Section
him to
6.
continue.
You file a suit under Section 6 because you have been illegally dispossessed.
Right, sir.
That's a quick remedy. If the property valuation is up to 10 crore, city civil court, about 10 crore, come to the High Court.
Right, sir. Right, sir. I get it. I'll also connect offline. Thank you.
Yes. All the best. और किसी कुछ पूछना है? Anybody wants to have any problem? Abhi civil lectures will conclude today, and next time I will take up criminal trials, trial before a court of session, trial before the magistrate in warrant trials, and summon cases. Very interesting there. As in my junior days, I used to conduct a lot of criminal trials too. Of course, I am conducting both now. Mostly now civil cases I am conducting. Okay.
Right, sir.
Oh yeah. Any questions? We'll wind up now. If there are no questions further, Sally will inform you the next lecture probably.
Thank you, sir.
Okay. Bye bye. Good night. All the best to everybody.
Sir, so just went through the Nagin judgment. So it just reestablishes that there will be no overlapping of judgments, overlapping of jurisdiction, and only presidency court will have even after it is lapsed.
Yes.
Yeah.
Keep reading judgments every day. You will learn the law. The best way to learn the law is keep reading. Keep reading. Bare Act रखो, एक judgment पढ़ो. Without a bare act of any provision, don't read the judgment. You will not understand. And don't read commentaries. Commentaries are misleading. I don't read commentaries. Only bare act and judgment of the Supreme Court or High Court.
Oh, sir, I have this. Thank you. Thanks.
Okay, all the best. Good night.